Good evening. Welcome to Left, Right and Centre. I'm Vishnu Shom. On the show tonight, the new proposed laws to curb atrocities against women and children in Maharashtra were meant to enforce far stricter curbs on offenders, the death penalty, life sentences, big fines and speedy trials. But there are many, including leading women's rights advocates, who say that the laws are patriarchal, anti-women and negate the very offence of rape. This is the letter, in fact I have it over here, that they've written to the Chief Minister. I'll be discussing the contents of this letter. This is Maharashtra Shakti Bill, justice in sexual assault cases. That's our question. Or is this based on patriarchal provisions, as has been alleged by a number of women's activists? But to set up the debate that we have over here, let's go through a couple of key points. Firstly, what exactly is it that the Shakti Bill proposes? Well, death penalty for rape and gang rape, the death penalty for penetrative sexual assault against children, 10 lakhs to acid attack survivors, money to be collected from convicts. The complete probe in cases must be over in 15 days. A trial must begin within 30. Threatening women on social media is a crime. It will be considered a crime. Making false complaints will also be considered a crime. So that's what the bill proposes. However, over 90 groups have opposed sections of the bill. What exactly are they saying? Well, women's groups have opposed sections in the new law clarifying consent. What is yes? What is no? Does one need to use the word yes or no at all? How does one define consent? Because if this is not properly understood, then those who are potential victims or those who have suffered may not get the justice that they seek. Now, the previous law had said that the absence of a no can't be taken as a yes in the case, for example, of intercourse. The new law clarifies on implied consent between adults. Now, activists say that the clarification negates the clarity offered by the present law, and therefore the bill feeds into a patriarchal construction of consent and conduct of women. We'll break this point down. It sounds a bit complicated, but this is absolutely critical. Now, activists have also opposed the introduction of the death penalty for rape. The certainty of a probe and punishment works as a deterrent rather than the severity of punishment is what they've written. They object to punishment for filing false cases. They say that it disincentivizes complaining or providing information regarding sexual offences. The effect of this bill will be to completely deny women any hope of justice. So these are a couple of points where several leading women's activists have problems with the law, which has been proposed. Joining us now, Mahesh Tapse, the NCP spokesperson, Mrunalini Deshmukh, the lawyer of the Bombay High Court with us, Veena Gowda, the women's rights activist and advocate, also Lalita Kumara Mangalam of the BJP. I'd like to thank you all very much for joining us. Veena Gowda, let me come to you first. Let's talk about the issue of presumption of consent, which is one of the biggest concerns. What you have said in the letter, which has been signed, is that what has been suggested now negates the entire definition of consent under Section 375 and the offence of rape. It's a step back for women's rights. In simple terms, what is your objection?
Before that, I would like to first communicate my appreciation to the present government, which has referred this bill to the Joint Select Committee.
Right.
Somewhere we feel that our voices have been heard.
Yes.
And I hope the Joint
That's a key
Select
point.
Committee
Yes.
Hears us. So basically now it is with the Joint Select Committee. But now coming to your question of consent. Now, what is the offence of rape? Rape is sexual intercourse against the consent of woman. Now, therefore, the prosecution has to prove the act of sexual intercourse as well as that there was lack of consent. So then the court, finally appreciating all this evidence, will say whether this was a consensual or non-consensual. If it is non-consensual, then it amounts to the offence of rape. Now, what happens in a general trial is that, as we know, rape often is, the statistics show us that stranger rapes are lesser, and it is, people who are known to the woman or to the child that commits the offense of rape itself. So therefore, so when the question of consent comes in, how do you prove consent? So injuries in the body, and the statement of the woman, etc. And so many women have different ways of reacting to when you're sexually assaulted, when you're attacked. Some may freeze, some may protest,
some may
push.
verbalize and some may not verbalize. I think that's
Yes,
the key point,
yes.
right?
So therefore, what happens is that because of this difficulty, post Nirbhaya and based on the recommendations of the
Justice
Verma
Verma,
committee,
yeah.
The definition, an explanation was added to rape, where consent was defined to say unequivocal agreement, unequivocal voluntary agreement by word or by gesture. So that then a yes has to be there in that before the act of sexual relationship. Now, what this law does is that it says if it is between two adults and the circumstances and the conduct of the parties show that there's a possibility that there was consent or implied consent, then consent will be presumed.
Right.
So if consent is going to be presumed, this means that even the police then get the power to say this is a consensual relationship. So you're taking away the right to even file a complaint. It's not before a judge.
Okay, so that's the key point, that the possibility of a woman actually being able to file a complaint safely is something which could be a problem, because of the law changes the way in which law authorities can potentially act. I want to go across to Mahesh Thapse more about this point. The point being made, and I'm reading from this letter, Mr. Thapse, is the amendment in the bill seeks to add explanation 3 to section 375. In other words, where parties are adults and the conduct of such parties from all circumstances surrounding the same appears that there was consent or implied consent, a presumption of consent will be made. How can anyone presume consent? I think that's the key question, Mr. Thapse.
Good evening, and thank you for having me on your show. This is Mahesh Tapase, not Tapse, Tapase here. See, it's a very technical debate in nature, and in fact, these are the points which Advocate Ms. Gowda has just put forth, and I've also been getting a lot of feedback as far as this particular aspect is there. But you have to see that the overall mindset of the government is to act or make an act which is so stringent that you want to deter people from making or committing heinous crimes against women and sexual offences against children. Right. So this is the basic principle on which the entire Shakti bill has been established, and it is put across the Maharashtra legislature today. I agree to a certain aspect that there might be some apprehension, but you have to also realize that the investigation is not going to be by a normal havaldar. It's going to be from an officer of the rank of a deputy superintendent of police, and hence all the questions, all the doubts which are raised in the minds of activists and other legal experts will be addressed, because the investigation officer, the team, is going to be headed by the deputy superintendent of police, and special court only for these specified offences of 376, 376A, AB, B, 376C and D. These are the changes we propose to make in the CRPC and the IPC and the offences against children.
So that's an important point.
Can I come?
Ms. Gowda, Ms. Kumaramangalam, I'll just come to you in a moment.
Yeah.
Ms. Gowda, the point that this is going to be looked at by police officers at the rank of DSP, that there be special courts which will be looking at this into the investigation itself.
Also, I would like to mention, Mr. Som, I would like to mention that the prosecutor will preferably be a lady. Okay. This has been specifically added in the
So does that answer some of your queries or doubts, Ms. Gowda?
No, it doesn't at all.
Okay.
Because the point here is that consent is anyway, non-consensual is anyway part of the definition of rape itself. When you're saying that this law is being brought in for safety and security of women, then why are you bringing in sections that are, that go contrary to that? Because like I said, I mean, if you read such a definition, then the only kind of rape that women will be able to prove is stranger rape. and which is, I mean, about more than half, close to most cases are of women, I mean, are from people who they know. So if someone goes on a Tinder date, for example, a girl goes on a Tinder date, she meets the person for coffee, maybe they kiss, maybe whatever that they do. Subsequently, there is a demand for sex and she says no, and there is forceful sexual relationship against her consent. Such a definition then will mean that this does not amount to a rape, because you will be seeing the larger circumstances. So my question is that let the courts decide that as they are deciding now. There is no need for us to indirectly bring in and creep in to the law these sections which actually show that the law somewhere doesn't seem to trust women, and that women will file false complaints.
Okay, I just want to go across, Ms. Gowda, I just want to go across to Lalita ji, who's been waiting very patiently. If you look at some of the other provisions over here, because I want to go beyond this point, because there are other issues here as well. The law provides for speedy completion of a probe and a trial, 15 days and 30 days respectively, special teams and special courts, right, in cases where women and children may have suffered, the death penalty, life imprisonment in certain cases, hefty fines. Are these aspects of the new bill that you agree with?
Vishnu, first, I'd just like to clarify that I'm not here as a member of the BJP. I'm here as a woman who has worked for 35 years with other women's causes. Right. Now, having said that, I agree largely with what Veena ji said, except the bit about the death penalty. But as you said, that's been discussed. The question you asked me, let me reply
no, why don't you discuss that? Because that's key. That's a key protest.
Sure.
Ms. Gowda would perhaps not agree with the death penalty,
cases,
but do you?
I feel that the death penalty in certain cases should be applicable. It should not be totally written off as being too harsh or something that will encourage rapists. I think it will deter rapists, but that is a very moot question. It's a very almost an emotional question among even us activists. But I do agree with Veena ji when she says that the whole question of consent should be absolutely explicit. You can't say that she may have consented. We presume she's consented. She appears to have consented. Women are judged, the time you go out in the night, the way you're dressed, you're wearing high heels, you're wearing a short dress, you're wearing this color, you're wearing too much lipstick. They will use any excuse. And right at the moment when she goes to file a complaint, the FIR will not be written because the policeman, regardless of his rank, patriarchy is absolutely rampant in this country. It has nothing to do whether you are an ordinary havaldar or a DG of police. Both of them can be equally patriarchal. The question of female lawyers also, let me point out, and I've said this ad nauseum, that women can be as patriarchal as men. So it has nothing to do with the lawyer's gender, right? Now, the presumption that a woman has consented, it cannot be accepted because most women, as already has been pointed out, have not been raped by strangers. They will be normally raped by people within the family, people who are close to the family, who they may have known well, who may they know, just know, a colleague, a friend, somebody they see at the bus stop every other day. And it's not fair to ask a woman to prove that she has been raped beyond doubt. This is what this law implies. And given the fact that really women have no agency in this country, we're not talking about people like me and Veena ji and probably Mrinalini ji. We are the 0.001%. But the ordinary woman who gets raped so often, and these complaints are never even filed, because women can't even get to the police station, forget about trying to persuade them that file an FIR, so-and-so whom I may know very well, who may be an uncle, a brother, or whatever, has raped me against my will. I mean, the rape means against one's will. The second thing is that this 15-day thing is ridiculous. Any state government may say that we will give special teams, but we all know the police is understaffed. We know that nothing can be done in 15 days, and even the 30-day trial limit is, I think, quite ridiculous. It's just not reasonable. It cannot and will not, and we all know it cannot take place in 15 days.
Okay, ma'am, so you've mentioned lots of points.
So
I want to go back.
Set a time limit, but a reasonable time limit.
Sure. I want to go across to Mr. Tapase. Mr. Tapase, on the point of death penalty, they've said numerous studies have questioned the potency of the death penalty as a deterrent in preventing crimes, Further, women and child rights and activists and scholars have repeatedly stated that the death penalty reduces the already abysmal conviction rates as well as the rates of reporting in cases of sexual offences. In fact, they've said a lot more on why the death penalty shouldn't be there. What is your view on this, sir?
It's a very debatable question. Some intellectuals may have a debate on whether death penalty should be imposed. Some might have a different view altogether. We have seen women groups absolutely condemning rapes and asking for the strictest of the strictest punishment as far as even death and even chopping off the genitals of the rapist. So these have been some of the views which have been openly expressed on television channels by a lot of women groups. So when the question of penalties of death, is it not right on the part of the investigative agency to see whether the heinous crime has been committed or not? So that is the entire premise. If you are going in for an investigation, the officer in charge will definitely ascertain whether such a heinous crime has been committed or not, because the penalty in question is death. I mean, it cannot be once ordered and once hanged. He cannot be brought back to life. So is it not right on the part of the investigative agency to ascertain whether the incident has happened due to a forceful rape? This is my first question. And as far as Madam the ex-National Commission on Women chairperson said that as far as Maharashtra police is concerned, we are quite well staffed, and this is only specified offence leading to only for 7-8 sections of the IPC and the CRPC. This does not have the entire array of IPCs under its purview. It is only for the specified section. Even the special courts will only be dealing with offences under these specified sections, not for all the offences. So I do not see why there is such an hue and cry regarding infrastructure, regarding special courts and regarding police force. In fact, we all want people from various sections of the society to intellectually contribute in such a way that the law is framed to deter people from making such kind of heinous crime. If you think that some more provisions can be made, some suggestion can be made, please feel free to write to the government of Maharashtra.
And I think it's welcome that this is going to a special committee and that you look at this. That's great news. Perhaps that will come up. Ms. Gowda, the issue of false cases, in the letter, you have written that there is a provision for there is a punishment in case somebody files false complaints or provides false information regarding sexual and other offences against women solely with the intention to humiliate, extort, threaten or defame the accused. The other way of looking at it is that a lot of women will not file cases because they will think that they are being threatened. They can potentially be threatened by this, right? That's the worry. What's the way around this?
One, I just want to go back to the death penalty. Death penalty is not merely an emotive issue. It's also a question of ethical issue. I don't think anyone should have the right to take anybody's life, including the state. It's an irreversible punishment, and I think it'll endanger women's lives, because he would say, I will rape her and I would rather kill her because I'm killing the only eyewitness. I mean, it'll endanger the women's lives, and I think, to me, it's non-negotiable in that sense as a human rights and a feminist lawyer. Now, coming to the question of false complaints. Now, every law is misused. Like I told you, we are talking about this law in the name of women and safety and security for women. And this is the manner in which patriarchal notions come in. Now, every law in the country is misused. Which special law within itself has a section for false complaints? It's only this and the sexual harassment law, because we're feeding into this into this myth that women misuse the law. Because if you're going to add this kind of a section, it will of course dissuade women from filing the complaint. There is shoddy investigation. There is I mean, not very well conducted trials which lead to acquittals. Now, does these acquittal mean that the woman has filed a false complaint? No, it does not mean that. And anyway, within the existing law, there are provisions for filing false complaints, perjury, defamation, etc. There is no necessity to bring in such a provision which will discourage and dissuade women. and which will actually go contrary, because I mean then it will not only be counterproductive, but women can be further harassed, and we know how difficult it is for women to prove the offense of rape, and it will turn out to be that any case of acquittal will result in counter litigation for the woman.
All right, let's try and get Mr. Tapase in for a response to that. On this entire issue of claims and allegations that the claims are fake, how does one ensure that women are confident enough to use the law, as opposed to being worried that they can't because they'll be targeted if they do?
I do not agree with the advocate Veena Gowda ji. The section in question here is the proposed section 182A. And I think a fair chance to the victim and to the accused both has to be given. It is there. It is the provision of law to hear out the accused and also the victim. So if such a stringent punishment is to be meted out to one section of the society or one particular gender, then there has to be a little protection just to ascertain that something negative or something by intent has not happened. I totally agree. No woman would want to do something by intent just to make a false complaint. But let that 1% or 0.1% element of no error and a little justice be there for the other gender also.
All right. One sec, Lalita ji, go ahead. Veena ji, one second. Lalita ji wants to go ahead. Yes, ma'am.
I am sorry. I can't really fathom this gentleman's reasoning. Rape is not a joke. If you know a woman who's been raped, as it is mentally and physically, she's in a condition where she won't even probably be able to talk. It's absolute
but I'm not
torture.
Ma'am, I don't think he suggested that it's a joke or anything of that sort.
The thing is that most women are doubted. When they are raped, it is, or even today, it is a woman who has to explain that I have been raped. Now, to say that, that you must give the man also the benefit of the doubt when he is the aggressor, it's not justice.
I never suggested that it's a joke. No rape is a joke, madam. I think I've been very consistently.
Sir, what you said was that the other gender should be given a chance. Now, in a rape, the man is the aggressor. This is not. If you say that a woman has raped somebody else, she should equally be considered an aggressor. But unfortunately, in our patriarchal society, it is the women who get raped. Normally, it is a woman or a child. Who's been raped. But the point here is that it's not a question of giving an equal chance to the person. And as
okay, all right, one second. Neither of you can be heard. Mr. Tapase, one second, Mrs. Kumaramangalam. Let him reply. You made your point, ma'am. Let me go back briefly to Mr. Tapase before I go back to Veena Gowda.
Out of context. Madam Kumaramangalam is quoting it absolutely out of context.
All right, he says, all right.
That's how most women would take it.
Ms. Gowda, go ahead with your last point. I need to start wrapping this up. Yes.
No, whatever on.
Can I just ask you, ma'am? Sorry, I thought rather than give you the platform, I may as well ask a question. And the question is this: it just seems, given how strongly various laws in the country advocate the death penalty, and even after what Justice Verma had said in the past, in extreme cases, the death penalty, why it just seems difficult for any state government which actually goes about a bill like this to say that no, that is off the table. Realistically, what do you achieve? What do you think you can achieve which would change this bill?
I think realistically now, what this law says also is 15 days for investigation, 1 month for trial, and 2 months for appeal. Now, this shows, this will also create a very shoddy investigation. 15 days is very little time. And with lack of prosecutors, 1 month is very little time for a trial. I'm saying there ought to be some amount of time frame, but this will not.
What else? Realistically, do you believe can be changed?
To have a proper, to work on our infrastructure, like I said earlier, and improve our investigative mechanisms, improve facilities in court, increase the number of prosecutors. I think the governments must now start allocating budget, putting money into improving the infrastructure, rather keeping on adding one law over the other.
So let me give Mr. Tapas a chance to respond to that. It seems to be low-hanging fruit, sir, when they say that, look, 15 days, nothing will get done. All of us know it can't get done in our system, not in Maharashtra, not anywhere else. So therefore, why not be more realistic about this? And why not allot a gender budget? At least have a conversation on that.
See, why not have a specified time frame when we have laws where there is no specified time frame?
Because it cannot be realistically achieved is the argument. How many cases have been solved in this country over the last, since the Nirbhaya rapes, within 15 days? A distinct minority of cases.
Let us go by your argument that it is not realistic. Why not let us try it out? I mean, what's the harm in trying it out? There is a provision for appeal, there is a provision for investigative time and the final disposition of the case. So, I mean, before anything happens, before the law is passed, we are free to write to the government. All the suggestion, objection, the government is going to definitely look into it. Now that it has been put to the Joint Select Committee, we are going to handle all the questions and all the suggestions that are going to come from the opposition.
All right, well, that's a good way to end this program. I'm completely out of time. The government will look at the proposals. That's real democracy at work. And let's hope we have more conversations like this. Thank you very much for being with us. Goodbye.